Good afternoon, everyone. Thank you for joining us for today's webinar, Getting to Guilty, Guiding the Jury's Response to Evidence. My name is Brooke Meyer. I'm the director of the Institute for Coordinated Community Response, and we will be hosting today. A few housekeeping items before we begin. We encourage you to use the Q&A box at the bottom of your screen, specifically for questions to the speaker. This just helps us keep track throughout the webinar. If you have any comments or would like to speak with your other attendees, you can use your chat box for that. And be sure to select all panelists and attendees in the blue button at the bottom of your chat box. If you have any technical difficulties, then in that instance, you can select all panelists and one of ICCR staff will assist. A little background on us before we begin. The Institute for Coordinated Community Response, or ICCR, was created in 2018 as a program of the Conference on Crimes Against Women. We are a training and technical assistance program that works with rural communities to improve their systemic responses to domestic violence. Across the state of Texas, we work with teams of law enforcement officers, prosecutors, and advocates from rural counties each year to take a deep dive into their current criminal justice system response to domestic violence and begin building the scaffolding of a sustainable, coordinated community response. In addition, we also host nationally available trainings like this one, and in-person trainings in Texas to ensure that rural communities everywhere have access to the most relevant cutting-edge training on domestic violence dynamics and collaborative solutions. And while our programming is geared towards rural needs, through webinars like this one, we're able to train practitioners from all over who are committed to eradicating domestic violence. So thank you all for being dedicated to this cause and for being with us today, whether you're from a big city or a small town. You can learn more about ICCR on our website, instituteccr.org, and I encourage you to sign up for our newsletter there to stay in the loop about all of our upcoming trainings. And I do have a few upcoming trainings I'd like to highlight. We have our next Rural Texas Advocates call coming up in a couple of weeks on March 23rd. We will be specifically talking about the new Texas SART requirement on this call. So I highly encourage you to RSVP at the link on your screen if you're interested in being part of that conversation. We also are partnering with the Institute on Domestic Violence and Sexual Assault at UT Austin to provide a 3-day fully virtual expert witness training. Now, I will say that this is only Texas and registration is now only open for prosecutors. So if you are a prosecutor in the state of Texas and would like to attend this free training, again, I would encourage you to register for that. This is a great interactive way to pair with expert witnesses in your communities and learn how they can support your case and help educate the judge and jury. And then we also have an in-person training coming up in Paris, Texas, which is north of Dallas, on May 4th. This is moving beyond just the facts, ma'am, techniques and victim engagement for documenting domestic violence. This will be presented by Julie German and Justin Boardman. So if you are within driving distance of Paris, Texas, this is completely free and we would love for you to join us. And then last but certainly not least, I have to mention the Conference on Crimes Against Women. We are so excited to be back in person this year in Dallas, Texas, May 23rd through 26th at the Sheridan downtown. You can visit our website to learn about all of our amazing workshops. There are over 200 different sessions to attend. We also have a pre-conference hosted by Kelsey McKay on misdiagnosed homicides and asphyxiation crimes. There are various price points for depending on what you are planning to attend, and we do have scholarships available. Those are first come, first serve, and we are receiving lots of applications every day. So be sure to visit the website and apply for a scholarship there if you'd like to attend, but your agency doesn't have the funds to send you. All right, and with that, I am excited to introduce today's presenter. John Wilkinson is an attorney advisor with Aequitas who presents on trial strategy, legal analysis and policy, and ethical issues related to violence against women. He conducts research, develops training materials, resources, and publications, and provides case consultation and technical assistance for prosecutors and allied professionals. John has presented extensively on the investigation and prosecution of gender-based violence at the local, state, national, and international level. Additionally, he leads Aequitas's Innovative Prosecution Solutions Project, working with prosecutors' offices across the country on innovative and evaluated approaches to violent crime. John, we are so excited to have you here today. Thanks for being with us, and I will let you take it away.
Awesome. Thanks, Brooke. Let's see, where is mine? There we are. Thanks, everybody, for tuning in. As Brooke was listing off all those trainings, there's a couple that I would definitely want to attend. The Conference on Crimes Against Women is awesome every year. There's so many great topics, and you get a great array of things. And then the Paris, Texas training also sounded amazing. So I'm sure they're all great. But anyway, today we're going to talk about getting to guilty, and we're going to focus a little bit. We're talk about domestic violence generally and how we want to approach those cases, but particularly how we're going to work with our juries and get them to that guilty, because there's a few different things that juries get hung up on in these cases. And so we just need to strategize ahead of time about how we're going to get those folks to the guilty, to the point where they're able to say guilty in these cases. These cases are tougher, I think, than most of our cases that we try. So I was an assistant Commonwealth's attorney in Fredericksburg, Virginia. So we were a small city about an hour south of DC, so a little bit of a rural city. So I tried everything from traffic offenses to first-degree murder, but I focused a lot on domestic violence, homicide, sexual assault, and I was on our sexual assault response team. And being on our sexual assault response team is what really opened my eyes to how these crimes are different, because we work very closely with our victim advocates in our sexual assault response team. We had our myself, our experienced rape detectives, our victim advocates, our rape crisis center folks, and our sexual assault nurse examiners. And we just talked about these crimes, how we can improve our response, and how these crimes work and how they're different. So I probably used to try every crime the same. So I try a sexual assault or a domestic violence case like it was an auto theft or a burglary or something like that. And you just can't do that and expect to get great results. You've got to think differently about these cases because they are different. And so we'll talk a little bit about all of that as we go through this presentation. I'm an attorney advisor with Aequitas, and Aequitas is a state resource for state and local prosecutors on violent crime. We focus particularly on violence against women crimes or gender-based violence crimes. So intimate partner violence, sexual violence, stalking, human trafficking, things like that. If you have any questions or want any assistance on any cases involving violent crime at all, but particularly those cases, reach out to us. We've got a lot of resources on our website you can check out. We try and be innovative. We check in with folks practicing in the field to find out what the latest issues are and how they're being addressed. And we try and be very practical so that we can help folks day to day in what they're doing. So check us out. You can also reach out to us. There's, I think now 7 former prosecutors on staff at Aequitas, and that you can email or call us, and we will talk through cases that you have or issues with your system response, or we'll do research for you. If you need a particular issue researched, we can turn that around very quickly. We get calls sometimes in the middle of trials, like I need an answer to this question. We've had folks who have had a defense expert sprung on them last minute at trial, and we were able to sort of research the background of the expert and provide law and guidance on what that expert could and could not testify to. So anything like that. We do a lot of training. So we have resources online that you can check out, recorded webinars. You can also request a virtual training or an in-person training. Virtual trainings usually don't cost a thing. We can do them for free. There's nothing to it. And the in-person trainings, you have to pay for our travel. But everything else is covered, our time and things like that. And we partner with a lot of different organizations that are working in the same area as us. So we try and stay informed and collaborative on that. Thanks. AJ just shared the link to Aequitas, so you guys can check that out. I think I accidentally skipped one. We are supported by the Department of Justice's Office on Violence Against Women. So they fund us. They don't necessarily agree with everything I say. You guys can make your own minds up about that. And I give fair use attribution to the materials here. They're often some taken from public, some from folks that we work with regularly, and we just give that fair use attribution. All right, so what we're going to talk about today is how we're going to get that jury to guilty. And it starts with voir dire. Really, it starts before then. We have things that we have to do in every case of, I'm going to focus on domestic violence today. So every case of domestic violence, we should be approaching in a certain way, in an evidence-based way. And we want to collect the evidence and then strategize how we're going to get it in. And then it's not just about the evidence that the police are collecting at the scene, getting information, statements from the victim, maybe from the perpetrator, maybe there are other witnesses, children witnesses, maybe sometimes. It's also about what we know juries tend to get hung up on in these cases. And it's usually myths about how domestic violence works. And that's the thing that I want to make sure I get my jury over, because for sure, I anticipate the defense is going to hammer away at myths and try and make the jury disbelieve the victim simply because they behaved like a victim of domestic violence, someone who has gone through the trauma of domestic violence. And that makes people do things that maybe if we haven't been through that, we don't understand or appreciate. So that's what we have to do, is we have to strategize how we're going to educate that jury. That part starts in voir dire. And then we're going to pepper throughout the presentation of our case the order of the witnesses that we call, the direct testimony that we elicit, the physical evidence that we present, all the way from jury selection, opening argument, through to closing argument. We're going to hit back again and again and again at the things that we're educating the panel on, the evidence that is important in this case, why this victim should be believed, and then we'll do that throughout the case. We're also going to identify issues that might require expert testimony. So when we think about things that jurors get hung up on, myths, like if you're in an abusive relationship, if you've never been in an abusive relationship, you might say, why would anyone stay in that relationship? I can't believe this is happening. I would just leave, or I would call the police immediately, or what have you. So we might need an expert to help explain that to a jury. That is not something that everybody understands. That's not in the common knowledge of individuals who don't do this work. So that's one strategy. We'll have other strategies. We might use the voir dire of the entire panel to educate the jurors with the experiences of members who show up who have either had a friend or a family member who's been a victim of domestic violence, or maybe has gone through a domestic violence situation themselves. And then we'll also employ themes that put the evidence in context of the common experience of the jurors. So we definitely want to make sure that we're able to communicate what's really going on in this case. This isn't an argument that went bad, that got overheated and suddenly turned violent. This is a pattern of abuse. This is about power and control. Those are the themes that we want to put in the minds of the jury. We need the evidence to make those themes work. So it all starts with that thorough investigation. So those are some of the things we'll talk about. Here's some of the things that might be going on in the minds of the jurors. You know, and I always say that in the minds of the jurors, it might also be going on in the minds of those investigating the cases or those prosecuting the cases. And so we have to make sure that the folks that are working in the criminal justice system understand how these crimes work. We're not going to be a ton of help to those victims and to getting these cases prosecuted or getting them to guilty. If we don't understand how these crimes work, we're not going to do a great job here. So working collaboratively, making sure that people get education on how these crimes works is important. But we know some of our jurors are going to think, boy, this victim didn't act like what I think a victim ought to act like, not having ever been a victim. I feel like a victim would immediately call the police. A victim would immediately tell the police everything. A victim would show up to court. A victim would be anxious to tell their story, things like that. We know if you do this work, that's not how it works, but that might be in the mind of a juror. If she didn't bother to show up for the case, how can I believe any of this happened? I'm going to use she for the victim and he for the offender. We do have men who are victims of domestic violence, women who are perpetrators of domestic violence. We have same-sex couples who are victims and perpetrators of domestic violence, but I'm just going to use those that way. So I'm not trying to say that those other relationships don't happen or those other things don't happen. Why would she stay in a relationship like that? If someone did that to me, I'd call the police right away. These are some of the things we can anticipate that our jurors are going to be thinking, and just presenting the evidence of what happened may not be enough to get them over these humps. These are going to be in their head. The defense is likely to be reinforcing these myths. And so if we don't have a specific strategy to get these folks over these humps, we might not have as much success as we would hope. Sometimes the facts of your case really are there. There's an incredible amount of violence, and you get the good statements and things like that, so that you can get a guilty verdict, but not in every case, right? And there's a lot of these cases where we need to really strategize about how we're going to educate that jury so they understand that these are common things that a victim's response to the trauma of domestic violence sort of drives this. So we want to make sure that we have that in our mind. So how are we going to do this? We're going to encapsulate the evidence in a theme. So a common theme for a domestic violence case would be, this is about power and control. This is not a case where an argument went bad. This is about power and control. One party's need to control the other party. And then you're going to need that evidence of power and control in this relationship to demonstrate that. And so our investigations have to bring us that evidence. If we don't get it in the initial police report, we need to do additional investigation, right? And we need to do it quickly while we have a victim who is forthcoming, because that may not be the case throughout the pendency of particularly a felony domestic violence charge. That's a long time. At least in my jurisdiction, that was a long time that a case would be pending. All right, so we got a comment here. Jurors don't understand victims stay in abusive relationships because of economic duress, and the predators stalk and retaliate through third parties, even when there are restraining orders. When the victim asks people with firsthand knowledge to come forward with them to police, the witnesses recant because of their fear of the predator. And so this is a great comment. You're bringing up a ton of really important points here that folks don't get, and that often go on. So you have lots of power and control tactics. Economic duress is one of them. Stalking. I think that's such an important point to make about domestic violence relationships. We often focus on the immediacy of, say, a violent act that happened one evening and in a domestic violence investigation, and we don't look beyond that. When we know right up front, these are pattern crimes. These are things that happen over time. And so if there's a call to police, there's likely things that have happened before, and there are likely things that will happen afterwards. So we need to stay on that. And stalking is one of those things that's probably going on. It may not be going on in every domestic violence relationship, but I want to look for it in every one. When I hear domestic violence, I want to automatically think about stalking and look for those things. Does that abuser call the victim at work constantly, 10, 15 times a day? Another classic one is checking the odometer on the victim's car, because they know the mileage to and from their job, and they should not be going anywhere else. And it might be accompanied by questioning them about that. So that stalking point, I think, is a great one. It might not be something we think about in a relationship, a domestic relationship or an intimate partner relationship, because people live together, right? But there probably is stalking going on, and we need to think about it. And then how abusers can intimidate and threaten not only the victim, but others around the victim. So great points across the board that we need to think about and address. And we got another question. Is it appropriate to implore the jury to think how they would react to being in the victim's position, or is that inappropriate use of emotion? So I probably wouldn't ask that way, but I do want to get in the jury thinking about that. We'll talk about some of these things when we talk about jury selection. And one thing I do want to mention up front, and I'll probably mention it again, is for folks that are trying these cases, and even for those that are not trying these cases, if you're working closely with prosecutors and you work in advocacy, or you work as a detective or in medical, we have what we call sort of canned voir dire questions, just lists of voir dire questions that you might want to be asking your jury in your domestic violence case. You're probably not going to ask every question that we have in our list of questions because your case will be specific to a certain activity, a certain violence, things like that. And so, but there are a long list of questions, and they're topics that you're probably going to want to address. So those are things that I would want to do. So when I'm trying to put the jury in the position of the victim, I might ask a question like, can you think of reasons why a victim of domestic violence or intimate partner violence might not want to come to court and share what happened? And so I'm sort of doing, I think, what you were suggesting, but I'm asking it in just a slightly different way, rather than say, put yourself in the position of that victim. But we're kind of doing the same thing. And we're asking those questions so that they can start thinking about, well, yeah, maybe there are. And then those on the panel who have experience with domestic violence might really be ready to volunteer what their experience was, whether it's their personal experience or whether it was of a family member or a close friend. They could say, yeah, they love that person, or yeah, they're afraid of that person. I can imagine they might not want to come to court because it would be safer to not come to court than to come to court. In those relationships, there's manipulation, emotional manipulation, there's threats and fear in those situations. So we want to get those answers coming out, and we, even if everybody doesn't answer that, I want to plant that seed of thinking about, hey, maybe there is a reason why that victim's not here, and maybe I can believe what the state is telling me through the evidence, even though the victim's not here as a witness today. Or if a victim were to get on the stand and minimize what happened, can you think of reasons why they might minimize, or think of reasons why they might not tell the truth on the stand today, if you have a victim that's recanting, or you anticipate is going to recant or testify on behalf of the defendant, things like that. So excellent question that brings out what you want to do. I think, jury selection is a tricky process. It was not my favorite thing to do, but the more you did it, sort of the better you got at it. I would always have someone who would help me do jury selection. You may not have that luxury, but I would typically, it was our victim witness coordinator, who was our office-based, system-based advocate in my office, who could sort of take notes and look at the jury and sort of mark jury number. They answered, I'm taking notes as well. And then together we can figure it out. And that person, so as I'm sort of looking for answers and I got multiple hands going up and I'm talking to different people, that person is able to take notes very quickly and share with me very quickly what they saw, what they thought. And sometimes our victim advocate, I just really think she just had a good eye for things like body language and attitudes and things that might come across that even, I'm paying attention to that too, but maybe it doesn't click with me as much as it does with her. It's just great if you can have somebody help you. Sometimes it might be a detective, but just somebody to help you sort of spot what's going on in that initial panel that in my jurisdiction for a case like a domestic violence felony would probably be 50 or 60 people that we would call in. And then we would whittle it down to 12 or 14, depending on if we're going to have alternates. So these are great questions, and just keep them coming, and we'll try and answer them as they come up, and I'll just try and keep going. So we want to also turn our common challenges into strengths. So things like, maybe you wouldn't come to court if you had somebody who was threatening you. Now, if my investigation is revealing that there's intimidation going on or emotional manipulation going on after the crime, which is when we really want to start looking for it. So even though we've made an arrest and we've charged, that doesn't mean our investigation is over. I just know things are going to happen after that arrest. And that arrest might be what is precipitating action on behalf of the defendant to try and evade accountability by getting that victim to not come to court. And usually, or more often, I should say, it is the emotional manipulation tack that they take. And we really want to look and listen to jail phone calls, right? Because if that abuser is locked up pre-trial, that is when they're going to start making those calls. I got to talk to her. If I can talk to her, I know I can get her to not come to court. And then you'll just see it in those calls, those appeals. So if you don't have somebody who is looking for those jail phone calls, your domestic violence docket just may be too big to listen to every jail phone call for every defendant who is incarcerated pre-trial. Not everybody's going to be incarcerated pending trial. Some are going to get out. But if they are, let's try and find somebody who can, sometimes students, criminology majors, if you have a local university, might be people that want to volunteer at the local prosecutor's office and listen to those calls. So think about that. And then when we have that evidence, we can turn that challenge into strength. She's not here. Yeah, there's a good reason why she's not here. And here's the evidence that tells us what that is. We also want to keep that a focus on the offender because typically trials that involve domestic violence and sexual violence end up being about what the victim did or didn't do. No victim of domestic or sexual violence would ever do this, would ever delay in calling the police, would ever stay in that relationship, would ever can have continued contact with their with the person who assaulted them. Well, we know that's not true, right? That happens all the time. But those are the things that those trials become about. And if that's all it's about, we're not going to have success. So we have to keep the eye of the jury on the offender, what that offender did, all the different things, all the power and control tactics. One of the great things for those who are familiar with the power and control wheel, which is probably everybody, is that when we look for that evidence of power and control, that's powerful evidence that I can use in my trial. So you talked about the economic, that first question or comment talked about that economic abuse. Let's look for that. That's not something a victim of a physical assault on one day or evening might think to share or think is important, but it is important to me. I want to know about that because if I can get that into trial, that's going to help me demonstrate, oh, look, this is not what most people's relationships are like. This is somebody who controls every aspect of this victim's life. They get an allowance. Maybe the abuser doesn't even work and still controls the finances. Things like that. That isolation. How do they keep them away from friends and family? Emotional support. Have they ever threatened or done anything to a pet? That last source of support for a victim sometimes. Looking for intimidation, minimization, blaming the victim for things, using the kids. All of those things on the power and control wheel can be important evidence. They're not things that a victim would think to share. I don't think I would think to share if an officer was interviewing me about an incident that, oh yeah, and he controls all the money. It's just not something they're going to particularly share, but we should be asking about those things. What are some of the things that are going on in this relationship that demonstrate power and control? So that's how we'll keep that focus on the offender in these cases. We also need to establish a connection between the jury and the evidence and the victim as well to the degree we can. I don't, depending on who your victim is, I just want to introduce who that person is to the jury a little bit in my case so that they can maybe connect with them in some way, shape, or form. We do this a lot. I think about in some of our sexual violence cases, particularly where it's a woman in prostitution is the victim, and they, of course, are targeted with lots of violence and sexual assault, as you can imagine, because they know they don't have a good relationship with the police. They're likely not to be believed, things like that. There often are alcohol and drug abuse issues in folks that are involved in that work. And so that is someone that we really have to strategize. You may not see that person on a domestic violence docket, but it's somebody that I want to introduce as a person to my jury through the evidence and through my direct examination so that they don't just see a label or someone that they're not going to care about. And we'll do that connection in these domestic violence cases between the evidence and the jury as well, particularly in voir dire. All right, so some of the basics before we get into how we're going to get the jury there is, one, we've got to support that victim. Doesn't matter if they're going to participate in the trial, in the investigation, let's just get them the support they need. As our great team of detectives would always just say to me, after a case, maybe we lost the case or maybe a victim didn't show and we couldn't go forward. That's okay. We'll get them next time. Well, supporting that victim is going to be the best way to get them this time and next time. I just always want to treat victims with respect, always want to make sure they have the support they need, and always want to make sure they know they can always reach out to the police for help and to the prosecutor's office for help. So supporting the victim is really important. We know that victims don't appear for trial often in domestic violence cases. that's part of being a victim. And I never want to punish a victim for being a victim. So if they are unable to come to court, if they make a safety decision that it's going to be safer for me not to go to court than to go to court, I don't want to punish them for that decision. So I'm not looking to arrest victims or charge them with false police report or anything like that. To me, that's just punishing a victim for being a victim. In my jurisdiction, we used to do that. I never saw it yield any positive criminal justice end when we did that. So really, you got to think twice if you are engaging in any kind of activity like that with regard to victims. They need support, not coercion. We also need to collect evidence and get it into trial. So we want to make sure we get as much evidence documented independently as possible and then get that into trial. So we'll talk about those two things. All right, and so just being victim-centered is sort of part of what we're doing, recognizing that these victims have gone through trauma, and it's an ongoing trauma, right? If you're in a domestic violence relationship, are you walking on eggshells your whole time? I mean, when I go home at the end of the day, that's a place I can totally relax. That may not be true for a domestic violence victim. They have the stress of work, and then they go right home to the stress of home. We got to recognize that and make sure that we understand it. Every decision we make in the case may impact that victim. So anytime I agree to a continuance, now it might be a legitimate request for a continuance, and so opposing it might create error, which we don't want to do. But if I don't have to agree to a continuance, I want to think about how that impacts my victim. Discovery, turning over discovery might impact a victim because there may be something that was revealed during the investigation or that the victim told me. Every time I interviewed a victim in preparing for trial, I learned something new about the case every single time. It's just people tell things in different ways. I ask different questions. Their level of comfort is different with different people. And I just learned something different and new every single time. So sometimes I have to turn that information over, right? We share that information with the defense. There's no trial by ambush. The defense is entitled to it. So we have to turn it over. But I know that's going to impact my victim. So before I turn it over, do I want to connect with victim services, whoever's working with that victim, and say, hey, we're going to have to turn over this information. Do we need to do any safety planning? Do we need to prepare the victim? Is there anything that they're worried about? Is there anything we can do to help? So just we know these things impact them, and let's be aware of that and respond appropriately. We always want to have victims' rights, safety, privacy, and well-being as our top concern throughout the investigation and prosecution. Sometimes as prosecutors, I think we think about the safety of our case first and the safety of our victim maybe a slight second, and it should definitely be the other way around. Always, victim safety is always first and foremost. And then we want to make sure we have culturally appropriate trauma-informed services for the victim, whether or not they participate. Don't wait for to get a victim who, doesn't speak English or an LGBTQ victim. Let's make sure we have built those relationships ahead of time so that when we do get those victims, which I anticipate we've all either had them or will get those victims who are not maybe in what we think of our general population, that we're ready to help those victims in the way that they need help. That's appropriate. Maybe a victim who's an immigrant. That their immigration status is being used against them. Are we ready to help those victims? Let's make sure we've got that ready to go. Safety is going to be important. So we want to think about protective orders, no contact orders. And when there are violations of these orders, we want to respond quickly and appropriately to make sure that that offender is held accountable even prior to trial. We want to support victim autonomy, keep them informed about everything that's going on, check in on them to make sure everything's okay, that the situation hasn't changed. Maybe somebody's been released from jail, or maybe someone who's out and has been abiding by the no contact order is suddenly not abiding by it. Safety is not a static situation, it changes. And so we want to make sure that we keep informed about what's going on with the victim, keep them informed about the case. I don't want months and months to go by. And look, as I say these things, I've done all of these things. So I'm not like, this is how a perfect prosecutor acts. I've done them all, and I've learned lessons from doing things wrong and then having a team help me okay, we can do a better job on these things. So, and we also want to include the victims in the decision-making process to the degree we can. I want them to tell me everything that they're concerned about, what they want to see happen, and then to the degree I can do those things, I want to do those things. I can't always do what the victim wants me to do. And so I want to make that clear. I also want to be upfront and honest with the victim, and I want them to be honest with me. There might be something that the defendant has planted in their mind that is going to be, hey, if this goes forward, I'm going to have to tell them about whatever embarrassing facts I know about you, because they're in an intimate relationship. They know everything about each other, but there are things that I can maybe keep out of evidence. Working closely in a team with advocates who are working, community-based advocates and system-based advocates who are working with victims, sometimes they can vouch for me to say, hey, you can share your concerns with Mr. Wilkinson or with the prosecutor. I know he's going to try and protect that or protect you in this case. And so I can file a motion to keep some of that information out. So we definitely want to make sure that we're thinking about that and keeping that victim involved. We want to maintain the victim's privacy. So we might try and redact information that we share in discovery about certain things. We might want to do motions eliminate to prevent the defense from introducing certain evidence. One of the things I think about regularly here is when we're collecting evidence, almost every case now has a digital evidence component. There's typically evidence on one of the parties or both of the parties' phones, either the perpetrator and the victim. I don't want to take a victim's phone if I don't have to. People live their lives, big portions of their lives virtually today, and a lot of things are on that phone that might make that victim very uncomfortable. So if I can get away with taking screenshots of text messages or downloading or recording voice messages that were left, things like that, or getting photos of the crime scene or injuries that the victim may have taken, that's what I want to do. I don't want to put that victim's privacy at risk. And if I do have to get the phone, then I want to make sure I am taking steps to say, we're not sharing 90% of this, and here's why. We got to be upfront with the defense about all of this, right? They have the right to know, they have the need to know these things. So we want to make sure they know that stuff. And then timeliness, we do want to manage expectations about how long this case is going to take. And we don't want to get cases continued. Even it might be a relief to a victim on a particular day that they don't have to testify, but it's just going to build up again. It drags out. It's just not good. If a case can avoid being continued, we should avoid that. Some of the things it says beyond prosecution, but they're kind of wrapped into it, is that safety planning. Sometimes the police are very good at and helpful at safety planning. Victim advocates in my jurisdiction were the ones who typically did it, and we're good at it. So I just want to make sure that there's some safety planning being done. If a victim is staying with their offender, that they're not separating or court ordered to be separated, I want to make sure they have safety plans in place. If they are separated, same thing. Let's have safety plans. Let's make sure somebody's doing danger assessments with victims. It might not be something they're going to share with the prosecution, but I just want to make sure it's being done. If you have a police department that does the lethality assessment program, then that will typically be shared with me, and I just want to know that information. But I want to make sure an assessment is done. When I know that information, it gives me a sort of a better idea of how dangerous this individual is. They're not perfect instruments, right? So there's lots of things that might not be on an assessment that still may raise a red flag for me in a case. So I want to respond appropriately regardless of what the danger assessment says, even if I have an inkling that this is a more dangerous case than we think. We also want to engage in trauma-informed interviewing. So understanding how that trauma impacts the victim, providing support and addressing the impact of that trauma. It's really allowing the victim an opportunity to describe what happened to them their own way. So it's a lot more listening. I think Brooke mentioned Justin Boardman's doing a training, and I've seen Justin do this, and he's really, really good at that trauma-informed experience. It's almost painful for me, maybe you can tell by how fast I talk, that those silences are awkward. And I've just seen Justin do it where it's just a lengthy silence where I just want to jump in and say something, but you just wait and wait, and he gets this great information from victims. So that part, allowing that victim to tell their story their way, is really important. And we want to prepare them for what an effective direct examination is going to look like, what to expect, how it's going to work. Part of safety planning, I always think, is not just keeping that victim safe at home, but keeping them safe when they're coming to court, because we know they're going to be in the presence of their abuser, right? Particularly when they're out of custody, because they may be roaming the same halls. We want to maybe think about their safety in just having to go through a public trial and share this awful information. So, of course, just doing simple things like bringing them over to the courthouse a day before or during a prior trial, so they can see, here's how it works. Here's where he'll be. Here's where you'll be. We'll have you waiting in this room, and then you'll come up. And then keeping them safe while they're on the stand during cross-examination, say, making sure that we object if the defense is going too far or too hard at a victim. Letting them tell their story is also important. That's part of safety as well. Domestic assault response teams are a great way to respond to these kinds of crimes. That collaboration is key, and it helps us understand more about how these crimes work. The education level goes up dramatically when you work closely with service providers. They also do a lot of great work in supporting that victim, which makes my job easier. Learning about medical strangulation is a particular tricky topic in domestic violence. It's extremely dangerous. Medical professionals can explain this really well when they have that strangulation training. So we definitely want to work closely with them. Law enforcement that has experience in this area and prosecutors working together is going to improve our response. And, it'll hopefully help us get more guilty verdicts, charge more cases, but it'll also improve the victim's experience going through what is a difficult experience, particularly in a felony domestic violence case. Even in a misdemeanor domestic violence case, it's a really difficult process. The vast majority of my docket was misdemeanor domestic violence, and then the smaller portion was the felony domestic violence, and which we had a lot of as well. But we just had lots of misdemeanor domestic violence. Very tough for victims to go through that. We do want to make sure they have that same support, and that we're not doing anything to make it tougher. I mean, I think we're all on the same page. We want to hold these offenders accountable. We want to keep the victims safe, but how we do our individual jobs can sometimes make it unnecessarily tougher on victims in these cases. So just things to think about. So of course we need that evidence-based case, and that's a case that's built on the evidence and allows us to hold offenders accountable, whether the victim testifies or how the victim testifies. Sometimes we get victims who, what we would call a soft recant, where the victim is minimizing everything by the time we get to trial. And so their testimony isn't great, but if we built up and documented all the evidence in the case, then that's not going to kill us in these cases, because we've got other evidence. So we got another comment question here. How can victims who are targeted by individuals and groups be supported when so many agencies and service providers in many areas ignore them completely, resulting in digital evidence timing out, loss of life, as well as ruined and shortened lives due to associated factors, including chronic stress? Wow, that's a tough question for me to answer. That's a big issue. So we know that victims are targeted primarily by their abuser, but also by others, and that our support may not always be there. We were very lucky. We had great community-based advocates and support. Not every victim takes advantage of that. And we do want to make it, I understand that they may not be able to take advantage of it at that time, but we want to make it as accessible as possible. And different places are coming up with different ideas to make it accessible. Training your healthcare professionals, which I think most places have already done, so that they can provide resources to victims when they share that information is helpful. I'm not sure I'm answering your question. This is a tough one for me. I don't. If you have another comment to clarify, or if others have thoughts on that, I think it's a big question, and these are tough. But that's what I think. We just have to keep trying to do the best we can, get as many support services as we have possible for victims, and help treat them with respect always. There is an issue related to other groups. Sometimes gang members are perpetrators of domestic violence, abusers, And then you've got the whole gang involved. You've got family members of the accused that will get involved, sometimes intentionally making it tougher on the victim, sometimes unwittingly, putting pressure on the victim because they're want to keep the family together, don't want to take the father away from the kids, emotional manipulation like that. So we definitely want that victim to share that with us. And sometimes it might be appropriate to intervene with those groups or intervene with the defense, things like that. All right, so our evidence-based case, we've got to collect this evidence. So the 911 call, we definitely want to preserve that regardless of who made that call. Whether it's the victim, it's going to be super important because it may be a victim statement that we can get in if we don't have the victim present, something that the offender said on 911 call, or that is captured on a body worn camera, or that is captured by an officer who just notes it. We want all that stuff, but maybe the offender is the one calling. Maybe the offender is heard on the 911 call. I definitely want to preserve that. The crime scene, I want to document, photograph everything that happened. Maybe we need a diagram to show how it happened. Maybe the crime scene shows that it's been cleaned up, and that might be evidence. Why would you clean this up between the time someone called police and the time that the police arrived? That's suspicious to me. And let me just see this one other comment. Have survivor document third-party contact intimidation as directed by abuser, since this may be a no contact violation and is a form of abuse. So that's a thank you, Kathy, for that suggestion. So that is a great suggestion that we want to know about that, and we might be able to use that, particularly when it is directed, or we can demonstrate that it was directed, or even by circumstantial evidence, we can demonstrate that it was directed by the abuser if we don't have that direct evidence. But anytime that is happening, I want to know about it. It might lead to another charge. It might lead to a violation of a no contact. It might lead to a charge of intimidation or obstruction of justice. It might lead to a charge against the third party. Every time we're able to do that, it sends a message to those in the community who regularly engage in this behavior to avoid detection. So great suggestion. Thank you. So we'll document everything about the crime scene. We want to document the condition of the victim, injuries. If there's lack of injury, I want to know that too. And we'll ask, we don't just say, I didn't see any injury. Just ask, do you have any injuries? Are you experiencing pain everywhere? In strangulation, for instance, there may not be, it's an extremely dangerous activity, but there may not be signs. So let's ask about things that might indicate, oh, they are suffering. That it's painful when I turn my head. Or they're very protective. If you go to, hey, can I look at your neck? And they're very protective because they've been hurt. All those things are important. So just want to document that both photographically and by asking questions about signs and symptoms. So signs are those things we can visibly see. Symptoms are those things we don't necessarily see, and the victim has to tell us about those. The clothing, the demeanor of the victim. Body-worn cameras are great in capturing this evidence. So if you do have body-worn cameras, those are powerful tools. We want to do the same thing with the defendant if there's injury or lack of injury, and make sure that we're thorough in documenting where that injury and asking about injury, because I've had defendants who have injured themselves after arrest and then said, oh, but they didn't ask me about these scratches on, the back of my neck or under my shirt or somewhere else. So we definitely want to look at that. Their demeanor. A lot of times you're going to have a victim who's very upset and an offender who's very calm. And they're going to maybe try and play up that, oh, she's been drinking. She's crazy. She uses drugs. She gets out of hand. I had to restrain her, things like that. And then medical records. If they're, particularly in strangulation, we definitely want to encourage that a victim receive medical evaluation, medical treatment, even if it's just an EMT. They don't really want to go to the hospital. Let's just get some documentation. And then see if we can get a release from the victim. Virginia Beach has a form where there's a medical release for a victim to sign in their supplemental domestic violence report form, so that they can get those records about this incident. It's a limited release to this incident if needed. So that's just a step saver. We want to get that historical evidence, or that 404B evidence, the evidence of other acts, prior crimes, things that have happened. So it could be in a police report, a criminal history. It could be something the victim or a family member or friend or coworker knows about. There might be prior relationships that are relevant. If an offender is abusive in a particular way, a patterned, unique way, if he's doing it in this relationship, he's probably done it in prior relationships. So you might be able to find that prior relationship and get that. If there are child protective services complaints, things like that, case files in our office, other medical records of abuse in the past that maybe a victim didn't identify as abuse, just said, oh, I tripped or fell, whatever it might be. If there are counselors or shelter workers that can share information, typically those are confidential. And so I don't want to break that confidence. But if they get permission to share information about what happened to the victim, that can be helpful too. And that 404B can come in for lots of different reasons. These are sort of the statutory reasons that we see. This is not an exclusive list. There can be other ways to get it in. But if we're trying to show motive or opportunity, preparation planning, intent, the identity of the abuser, and to demonstrate absence of mistake or accident. So these prior incidents show that this wasn't an accident. This has happened many times before. So things like that. These are all purposes to get that evidence in. And then we want to do additional investigation, social media, consistent. We want to make sure that that victim has had consistent contact with their advocate, or our office has had it. And if they're not, then that might be a red flag that something's going on. And we want to reach out to them, make sure that they're okay. We want to follow up with family and friends and neighbors. And those jail phone calls that we talked about are going to be super important. So really, those of you who are already looking at those can tell folks how valuable they can be in a case. Let's really proactively look for that. You might need to talk to your jail about what is needed to get those calls. If anything special, I mean, all those calls are typically recorded. So you should be able to get them and get some very good information off of those. And the visitor logs is an important thing too. Not everybody calls. Sometimes they know the jail phone call is recorded, so you need to come and see me in person. Now that visit won't be recorded, but the log will show, oh, wow, she came to visit him every other day for the 6 weeks prior to hearing, prior to trial. So I might want to talk to my victim. So tell me about those contacts if you can. What was going on? Did he ask you not to come to court? Was he asking you to drop the charges, not talk to us? Things like that. So when we do document, the victim has made a statement. Typically when the police respond to a domestic violence scene, it's kind of like that golden hour in medicine. That's when the victim's going to be most forthcoming with the information about what's going on, not just what happened that day, but what is going on in the relationship. And remember, that's the key in these cases, right? I definitely want to know what happened this day. That's what we're going to prosecute on. But I really need to know the history of that relationship, because that's going to be important. And that's when they're going to be most forthcoming. So let's document everything they tell us then and there, so that we get all that information. It is also when they're going to be most receptive to our resources. So that's also when we want to hook them up with, hey, we have these shelter, we have these advocacy, we have a hotline, we have folks you can talk to. We can help you out with childcare, whatever your resources are. Let's make sure they know about them right then. Because I think people just don't think there's any other way to live their lives. How will I manage without this individual who's also abusive? And there are ways to do that. So let's share it with them. So if we do document those statements, how are we going to get them into evidence? We want to look for, first and foremost, non-testimonial hearsay. Non-testimonial hearsay are those less formal statements that are not made to law enforcement typically, that are not meant to get someone prosecuted, but they're just statements about what happened because the victim needs to get help or the victim needs support. Some non-testimonial hearsay is made to law enforcement, and so we want to remember that. But those statements can come in whether or not the victim is present, as long as there's a hearsay rule that allows it in. So the defendant doesn't have a Sixth Amendment right to confront non-testimonial hearsay. Only testimonial hearsay do they have that Sixth Amendment right to. So that means we should be proactively looking for sources of non-testimonial hearsay. Testimonial hearsay are those statements that are a little more formal, that are made typically to law enforcement who are investigating the case, and the purpose is to get someone prosecuted, right? So tell me the facts, what happened, and I'm noting it. And those statements I'm going to use to charge this individual and get them prosecuted. If it's a testimonial statement, the declarant has to be present at trial and available for cross-examination, or they have previously been available, testified about this, and had there was an opportunity for cross-examination. Then it can come in about the same topic. Or forfeiture by wrongdoing, which is the theory that says if the defendant did something to make the victim unavailable for trial, maybe they didn't show up or refused to testify, something like that, then that victim's statements can come in if we can show that the defendant did something to cause that and that was his intention. And we'll talk very briefly about that going forward. The hearsay exceptions we're going to typically rely on are the excited utterance, the present sense impression. So the excited utterance is something that somebody yells out while they're under the grip of the assault. Typically our 911 calls, he's assaulting me, or he just assaulted, I just got beat up, things like that. They're still under the grip of that startling event. Present sense impression is when somebody is relaying events as they happen or just after they happen. So he's at the 30, he's at the 20, he's at the 10. That sort of is a present sense impression, and those are admissible. The then existing mental, emotional, or physical condition, my head hurts where I got hit, things like that can come in. And then statements for purposes of medical diagnosis and treatment can often come in. So when somebody is relaying what happened to them, I was struck in the head. Whether the identity of the assailant is relevant will depend on your jurisdiction, but there are theories to get in the identity of a domestic abuser or a sexual assailant in through a medical hearsay medical hearsay exception. So I'm not going to go into all of that today, but if anybody wants information about that, reach out to me. If anybody wants those sample voir dire questions, and we've got them for sexual violence cases, human trafficking cases, domestic violence cases, reach out to me. I can also just send them to Brooke, and then she'll have them. If you reach out to Brooke, we'll make sure, or ICCR, we'll make sure that you get anything that I talk about that you want. So who did the victim talk to besides the police? Now, we'll talk about the 911 call, but when I'm thinking about non-testimonial hearsay, I'm thinking friends and family, employers, coworkers, landlord, neighbors, those other professionals, medical, EMT. Those are people that are typically non-testimonial. In other words, the victim is not sharing what happened to them to get their abuser prosecuted. They're sharing it for some other reason. And I'm sure many of you have had cases where a victim, they were assaulted by their abuser, and then they called a close friend or a family member really to get support. And it's maybe that person who said, hey, you need to call the police right now, or do you want me to call the police on your behalf? And we encourage them to call the police, and then they do. Or they call the police and then they call that family member right afterwards to tell them what happened, because they need that support, just as anybody would, right? Something startling happens and you're going to call someone close to you to tell them about what happened. So those people are non-testimonial sources of hearsay. Those statements that the victim made to them are non-testimonial. They're not calling them to get them prosecuted. And if it happens close in time to the event, the assault, then the excited utterance hearsay exception may allow that to come in. So we want to ask about that for all these folks. Now, the 911 call or statements made to an officer at the scene where a situation is still maybe ongoing. If the victim is making statements to a 911 dispatch caller or an officer at the scene that is aiding the officer in meeting this ongoing emergency, like a victim says, he's inside, he's got a gun, he's threatening me, then that officer needs to know some information. Who is he? What does he look, where, what kind of gun, things like that. Is he alone? Blah, blah, blah. They need information to meet this ongoing emergency. And those are non-testimonial statements as well. And so we always want to think about that, know what the circumstances surrounding the encounter are, so that we can make an argument that these statements are non-testimonial and should come in because they are also an excited utterance because the startling event was ongoing and they were helping the police meet that ongoing emergency. So something that officers, advocates, prosecutors should be asking victims is, have you talked to anyone else about this incident, either before or after you spoke to the police? So assuming the victim called 911, did you talk to anybody right before you called 911? Did you talk to anybody right after you called 911, or after the police responded, or immediately after, before or after the incident? And if they did, that's our non-testimonial source of hearsay. And that is the excited utterance hearsay exception that should allow that to come in. So let's make sure that we're doing that. We also want to preserve testimony. A lot of our victims will not be able to participate in the trial. And so if we can preserve their testimony, say at a preliminary hearing in a felony case, maybe allow the defense to ask more questions. Normally we'd keep them pretty tight to our direct examination. Sometimes we might not even put our victim on for preliminary hearing. But if we do, we'll let them do a full and fair cross-examination. We'll provide them with any exculpatory discovery and any discovery we have prior to that examination. So it's a full and fair opportunity to do that. If it's preserved some other way, prior trial testimony or deposition, that might, as long as there's an opportunity for cross-examination. Grand jury proceedings do not afford that opportunity because there's no defense attorney in grand jury. Forfeiture by wrongdoing, I mentioned, it's just the defendant has the right to confront the witnesses against him or her, but they can forfeit that right if they do something to make that victim not available. So what you have to show for forfeiture by wrongdoing is, one, our victim is unavailable, which means we did do everything we could to obtain their presence, i.e. we didn't just send a subpoena to the last known address. We sent a subpoena and got personal service, or we got substitute service. We checked in on the victim regularly. We tried to track the victim down at home, at work, at school, wherever they might be. That we engaged in a reasonable efforts to obtain that victim's presence, and they're not here. And that there was some defendant's wrongdoing. And this is where jail phone calls can be important, because they come in and tell us, oh, he's been calling her regularly saying, please don't come to court. I'm going to change. I'm going to stop drinking. I'm going to get help. Don't ruin the family. Don't take the kid's father away. Things like that. That he actually pressured her or threatened her not to come to court, and that he intended that result. And usually the actions that they engage in will give us that intent. So that's forfeiture by wrongdoing. All right, so those are the basics that we need in our cases to be able to successfully prosecute them, to independently prosecute them, whether the victim is able to testify or how that victim testified. So we want to talk a little bit about jury selection. We want to connect that jury with the victim's experience and the life experiences of the jurors. And so we want to think about that as we go forward. We want to gather as much information about the jurors as possible. We would get some very bare bones information about the juror, their name, their address, their occupation, their age, things like that. But I might want more information. So I might develop a jury questionnaire to gather that information, so it gives me a little better insight. And anything I can do prior to trial is going to just make it a little easier. If I do it all during jury selection, which I typically did, then it just makes it a little tougher. So knowing some stuff, this person's background is not going to be helpful. Things like that. You might learn about things that are going on in a prospective juror's life that might interfere with their ability to hear the evidence. If you are going to agree to strike people based on a questionnaire, just remember the defendant must be present for that strike, or that could be error on the part of the court. Occupation, their responsibilities in their job, their family status. Are they involved in the community? Have they previously served on a jury? What's their educational background? Have they learned information about this case from any source? Have they made up their minds in any way? So some of these things we do by questionnaire. Other things we definitely want to do in person. As we're conducting voir dire, of course, we're going to be listening to the defense throughout the course of the case. They may be calling us to say, hey, we want an offer, or hey, I think you got a problem with this case. What do you think about reducing the charge to a misdemeanor? And then they'll tell us their theory. But you might also want to listen to the questions they're asking during voir dire. And then it might prompt you to say, Your Honor, I'd like to, based on those responses from the juror to the defense questions, I would like to ask a few more questions. And then it's up to your judge. And it depends on your jurisdiction. Every jurisdiction is different. Some jurisdictions, the judge asks all the questions, and the questions are submitted in writing. That makes it much tougher. But we want to listen to what the defense is doing. It might give us a heads up about what to anticipate at that point. The primary purposes of voir dire are to identify challenges to potential jurors that they cannot sit fairly on this case in our opinion, and here's our argument why. We want to make sure that they haven't formed a definite opinion as to the guilt or innocence of the accused. We want to make sure that they can follow the law and apply that law to this case. And we want to make sure that we have good information so that we can exercise our peremptory challenges. And those are challenges that we just get to automatically exclude. In our jurisdiction, each party had 4 peremptory challenges. You pick 4 people you just don't want on. You don't have to give a reason for those challenges. But I don't want to just randomly pick 4 people. I'm asking questions so that I learn about who's on this jury. It might not rise to the level of cause to strike a juror, to challenge a juror, but it might give me pause that so-and-so might be sitting on the jury. And it just, the more information I have, the better. It doesn't always work out that way. I have definitely had it blow up in my face because I didn't read the information right. I had a case where the next door neighbor of the defense attorney, who, we were a small town, so everybody knew everybody, right? Was one of the panelists on the jury. And so I'm thinking for sure he's going to strike her. He's not going to want his neighbor on there. And he comes to me right after we finish. I didn't strike her. He didn't strike her. It's like, why didn't you strike her? I thought you were going to strike her. I was like, I thought you would. She voted guilty. We got a guilty verdict in that case, but it was just one of those weird things. So just think about those cases when you're doing it and how you're going to exercise those challenges. And of course, we knew that it was the neighbor because we always ask, do you know the attorneys? Do you know the detectives? Do you know the victim or offender? The defendant is sitting right there, but I may have to bring detectives, witnesses, the victim in, because people don't know everybody by their name, but they might know them by sight. So make sure that we do that. Secondary purposes in jury selection is to build that rapport and credibility. This is the jury's first impression of you. So we want it to be a good one. We want to be ready. We want to have our questions ready to go, be prepared, engage in that conversation, be a little more comfortable with it. It just takes time, I think, to develop that rapport with the jury, but you definitely want to just be straight up, make sure they know that they can rely on everything that we tell them. We want to use this opportunity to educate them about these cases and diffuse the weaknesses. And I may use the jurors' own experiences to educate the entire panel, those that have some connection to domestic violence. I want to talk about that. And then we'll also use it to establish our theme and theory of the case. So as we build rapport, we're going to demonstrate leadership, command of the facts, command of the courtroom, things like that. We want to listen and observe what they're saying and what they're doing as we're asking questions. Body language is a big part of this. So look at that. And we want to be prepared. So, you know, a lot of times jury selection is like, it's the night before the case, or it's the morning of, and I'm like, oh, I got to write out my jury selection questions. All right, Dina, have you had experience with the police? Have you had things? Like, let's think a little more proactively and do it ahead of time. That's where I think our canned questions, our sample questions, could really help folks to think about, hey, I do have this aspect in my case, and I do want to ask about it. And these questions are helping me think about how I'm going to ask about it. You probably or may not use the exact form of the question that we have. You know your jurisdiction better than we do, but you might want to touch on those topics in the way that makes the most sense for you in your case. Just a quick note from a study in 2006. Jurors may lack confidence in the system. Over 70% of jurors surveyed believe that it's more important to do the right thing than to do the legally correct thing. And so if the defense is able to make them think, you know, maybe this happened, but finding this guy guilty isn't the right thing to do. Maybe they've been able to sort of tear down the victim through introducing erroneous evidence or evidence that has nothing to do with what happened. If we haven't been good at keeping that out, and then the jurors just think, yeah, I don't think the right thing to do is to find him guilty in this situation. So we've got to not only get their thinking that this is the right thing to do, that it's also the legally correct thing to do. So how am I going to ask my questions? A lot of them are going to be yes, no answers. We might have follow-up questions that we want to ask depending on how people answer their questions. We might want to ask, does anybody think differently about that? Does anybody here think that if a victim doesn't show to trial, that you cannot find the defendant guilty? Why do you think that? Tell me, does anybody think differently? It's also helpful to use we and us. Do any of us think this way? Do we think this, or do we think that? To sort of demonstrate that we're in this together. Leading questions or non-leading questions, I don't like to lead too much, but we often do ask those yes, nos. As long as they don't direct them to an answer, I don't want to do that. I want to know what they're thinking, not get them to just agree to a question the way I've laid it out. So I tend to ask more open questions. Obviously, you run the risk of jurors saying something that might taint the pool, so we have to be careful about that. And we definitely don't want to cross-examine jurors. But you will have people who say problematic things, and so we want to make sure that we don't have other people agreeing with those problematic things. So we definitely want to ask follow-up questions or demonstrate from others that that is not the thinking that we're looking for. We also may do individual voir dire to protect the privacy of jurors. For any domestic violence case or sexual violence case, I'm always going to have to ask, is there anyone here who has themselves been the victim of domestic violence? Is there anyone here who's been accused of domestic violence? Things like that. And so I might want to let those people answer further questions about their experience and to test if they can be an unbiased juror privately, not in front of everybody else. So I usually ask that question separately and then ask, is there anyone here who has a family member or a close friend who has been the victim of domestic violence or been accused of domestic violence? And then those that have family members who have been a victim or a close friend who's been a victim, I might ask more questions about that individual experience for the whole panel to hear. So it's not as tough going into those details. And depending, for the individual, I may not ask as many details. I think it's going to be tough for them to sit on this case potentially, but I don't want to eliminate people simply because they have a background that involved some association with domestic violence. So that individual voir dire is important. The other thing is, in a domestic or sexual violence case, often people who do have that experience will get struck for cause in those cases. And, it may be the first time that they've revealed that to anyone, that they are a victim of this. And so one of my colleagues would have a victim advocate standing by for those people who acknowledge that and then were excluded from jury service and then are just sent home. And just to have somebody say, hey, I just want to let you know, if you want to talk about this or if you want to look at resources, here are some things, just so that we don't send people home in a damaged fashion after they've had to reveal something for the first time. They're under oath, they take that seriously, and they tell the truth about it, and they've never told anyone before. So just a good practice to think about. Those biases against law enforcement, against the prosecution, related to domestic violence specifically, or something, there's alcohol and drugs involved in this case. Is there anybody who couldn't believe someone who had been drinking or using drugs about what happened? Things like that. Something about the defendant in particular that may be a bias, or the victim in particular that may be a bias, that we want to make sure we're going to identify those people who can't see past those things. The peremptory challenges are those challenges that we get for free. There's no explanation, but you cannot exclude people based on race or gender. Those are the two protected classes. There's additional, those are Supreme Court cases that say you cannot exclude people. The example here, United States v. Witham, is not a Supreme Court case, but there is Supreme Court case law that says you cannot exclude somebody based on their gender. And the Batson v. Kentucky is the Supreme Court case that said you cannot exclude people based on race. So that applies to both sides. So I typically would get Batson challenges when I excluded people who were Black, and I would have to explain what my race neutral reason for excluding those individuals were. And so it really just amounts to the one party saying, I noticed that you excluded these three individuals who are African American. Can you tell us the reason why that is, or we're making that challenge? And then the court would ask me what was the reason, and then I'd give them my reasons, which are based on my questions and obviously not based on anyone's race. And then the court would say, well, I accept those are race neutral reasons. It could be gender based. And there is another case that's not a Supreme Court case, but in a federal civil case that said the defense could not exclude an LGBTQ person based on their sexual orientation in that particular case. Not at the Supreme Court level, but if anybody wants that information, we're happy to share that case and that reasoning with them in case they're in that situation. So we can also, if the defense is excluding people that you think based on race or based on gender, then we can also do a Batson challenge and say, well, they've excluded these 3 women from my panel in my domestic violence case, which again, I just don't think you've got to ask questions to figure out who is going to be able to hear this case fairly. It has nothing to do with someone's race and it has nothing to do with someone's gender. So you got to make those challenges intelligently. If somebody is excluding somebody and you think it's just on gender, then you want to call the court's attention to this. And I'm getting this question, is this about the LGBTQ case that I mentioned? So I can't share it here. I'm going to have to send it to you or send it to Brooke if you want to. I just don't have it handy. But if you want, my email information is at the end of this presentation. So just email me, or if you email ICCR, they'll let me know and I'll send it right to you. All right. So laying the foundation for the victim's testimony, we're still talking about voir dire here, and we want to ask about the personal experiences of the individuals on this panel, particularly those who may have a connection to domestic violence. Again, I would ask about individuals, if you've been a victim or accused of domestic violence individually, and separate in a separate question, have you had a close friend or a family member who's been a victim? And then you might explore, did you know about this situation from the get-go? Did they eventually confide in you? Did they call the police the first time something happened? So asking these experiential questions and getting some of the answers that are invariably going to line up with your case and what your victim did is going to educate that panel. So now the panel that you're getting, maybe that person who answers isn't going to make it onto the panel, but the panel is going to hear it from this person. And then they're going to maybe hear it in argument from me. And then they might hear an explanation that the victim is giving for why they did what they did on the stand. And then maybe they'll hear it again from an expert because we've called an expert witness to explain it. And now those things maybe go out the window as far as the victim's credibility. Oh, these are not big deals. I understand now. This is how it works. So we want to think about using those experiential questions to establish a connection between the jury and what happened in this case. We have lots of issues, those adherence to myths in the domestic violence case. People just don't understand that victims stay with their abusers. They don't report the first incident to police. They don't come to court. They get back with the abuser, even in extremely violent cases. So those are things that happen. We know it. If you do any work in this area for any amount of time, you will know this stuff. You will see it. They blame victims for things, a victim who is abusing drugs. So is it understandable that someone who's living in a domestic abuse situation might turn to drugs or alcohol? Of course it is. So we have to make sure that we get that through, that you shouldn't disbelieve this individual because they're using drugs or alcohol. That may be a response to the trauma they're experiencing. So it doesn't mean you should believe them either, but it's just not a reason to disbelieve or believe them. It has nothing to do with it. Criminal justice or law background is something that could be an issue in these cases. Normally, we do look for people who have a connection to law enforcement because we think they're going to tend to want to hold offenders accountable. In these cases, it may not be the same because people just don't understand how these crimes work. So be careful about that criminal justice law background. Folks, unrealistic expectations about how these crimes work, people with similar family backgrounds or prior knowledge of the offense, those are potential issues that we want to look at. So we need to win the hearts and the minds of the jurors to get to that guilty verdict. The defense really just needs to win one or the other, the hearts or the minds. And so it's an uphill battle, and we've got to really go at jury selection, which is not, at least where I practice, was not something that we typically spent a ton of time on. I'm saying you should spend a ton of time on this and think about it and be prepared, and don't do it immediately before trial. You know what your case is. start thinking about it well ahead of time and get ready for it. The theory of the case drives the case. The theme holds it together. So whatever our theory of the case is of how this came to be, why the defendant did what he did to achieve whatever that end was, that's what we have to explain. We have to explain it in plain language to the jury so that they understand it. It's often great to pitch things to your colleagues or to someone who has nothing to do with the criminal justice system. We always had, I would like roommates or family members, or I would just throw out, what do you think about this? And I'd throw it out there and they'd shake their head or they'd say, yeah, that's awful. And so it helps us hone that argument or that theory that we're going to explain to the jury. Themes are things that we want to use in these cases because they capture the jury's sense of what's happening. They should be short and succinct. You might need to be flexible. A theme sometimes might come during trial. Like you've got your theme planned out and you've introduced it in voir dire, but the victim or the victim says something extremely powerful in the trial, or the defendant says something extremely stupid in the trial. And then we use that and incorporate that into our theme. And in domestic violence cases, just a simple classic theme is, this is a case about power and control. I've got to have that evidence to make that argument, but that's typically what my theme is going to be. But it could be lots of other things, like in a strangulation case, asking the victim what was going through your mind when he was strangulating you, and whatever. I could only think about my kids. I thought this was the end. I didn't know what to think. Whatever it is. But that might be your theme. All I could think of was my kids. And I'm going to hit that again and again and again, particularly in closing argument. The opening statement, we're going to explain sort of the theme and theory of the case, lay out the case maybe in a linear fashion so that they understand the scope of the case and what happened. It might include, if we've argued motions ahead of time, to introduce prior crimes, other crimes, wrongs, and acts evidence, then we can incorporate that. If we haven't done that, then I wouldn't incorporate things that I don't know for sure are coming into evidence. I don't want to promise something I can't deliver on. So only those things I know that the court has ruled on am I going to use, or things that I obviously think are going to come in. Sometimes the defense comes up with a unique theory for an objection, and I can't anticipate that, but that's okay. I want to undercut whatever I anticipate the defense to be or what they've told me it's going to be, create that empathy for the victim, and set the stage for the closing argument. And sometimes we have to use or repeat strong language, so just make sure the jurors are aware of that. Another tip just related to the closing argument, sometimes it is good, rather than to sort of map out or outline what your closing argument is going to be at a break between the end of the evidence and before we're charging the jury, you want to do it ahead of time and think about, these are the outline things I want to hit, the big things I want to hit in my closing argument. And that's going to help me organize my case going forward. I need to highlight this evidence, these questions, to my witnesses, arrange my witnesses. So in a trial, of course, we want the most powerful witnesses to be our first and last witnesses. In a multi-day trial, they're the first and last each day. And sometimes the other not essential information comes in the middle. So it'll help us figure out how we're going to get to that final closing argument. We never want to read our opening statement. We're going to tell the story, explain the details. We're not going to go into too much details, and don't overstate that case. As we're presenting the evidence, I skipped past that. We're going to think about those things that the jurors might get hung up on, and that's those responses to trauma. So we're going to think about presenting that physiological evidence, psychological evidence, and physical evidence, and tying it into our theme and theory. And so sensory details help us recreate that reality of the crime. What do you remember that strangulation idea? His hands were going right through my neck. It felt like I couldn't breathe. My heart was pounding out of my chest. I could only think of my kids, things like that. I couldn't believe this was happening. I could smell the gasoline on his hands, maybe he's a mechanic or something like that. All of those things are going to be powerful. So we want to lay those out in our when eliciting evidence, and we want to ask that victim about that as we prepare for trial. Sometimes it's more powerful in the preparation than it is on the stand, but I want to get that information in front of the jury. Occasionally, the victim is going to end up testifying for the defendant, or we might have to treat them as a hostile witness depending on what's going on. So we're going to end up cross-examining that victim, and we do not want to cross-examine them the way we might a defendant, which is typically aggressive. Or it starts out with things that we get them to agree on and then gets aggressive when there are things where we part ways. So we just really want to think carefully. We want to elicit the evidence that demonstrates this was an abusive relationship. Ask those questions. We want to establish the elements to make, for whatever our domestic violence charge is, if we need to, through this witness that is testifying on their behalf. But let's talk about those things about the relationship that the victim may share, not thinking it's as important, that the isolation, the economic abuse, the minimization of what happened, all of those things, any power and control tactics that we can get in there. So let's think about that soft cross. Don't re-victimize a victim just because they felt it was safer for them to testify on the defendant's behalf than to cooperate or participate with the prosecution. We may want to use expert testimony in this case, and so it might be related to physical evidence, the trauma or the victim's response to the trauma of domestic violence. That's going to be powerful. So think about that. Again, we have some resources related to that. We do training on introducing expert testimony about the victim's response to the trauma of domestic violence. This is a typical elements of the expert testimony statutes in most jurisdictions, that the subject matter is beyond the common understanding of the average juror, and these domestic violence dynamics definitely are. The information is reliable, and it will assist the jury in understanding the evidence. So if we can satisfy those three things, this evidence should come in. You also have to establish that the person who's going to testify is an expert. And then this might be some questions you would ask of your expert. Are you familiar with victim responses to the trauma of intimate partner violence? Is it common or uncommon for a victim to remain in a relationship with their abuser? The witness is going to say it's not uncommon for people to remain in those relationships. Why? What are some of the reasons that a victim might stay? Oh, they rely on that person for support, for housing. They love that person. They're afraid to leave that person. And one of the most dangerous times in a victim in an abusive relationship is when they attempt to leave the relationship. So we can lay out some more of this for you if anybody is interested in that strategy. And the closing arguments, again, we're going to summarize the evidence, right? We're not going to just lay it out in a linear fashion. We're going to hit it's like if you go and see a great movie. Okay, and just a quick question. Have you ever used the power and control wheel for educating the jury while questioning? I have not done that. That's a great question and a great idea. I don't know if my judge would allow me to do that. So I'd have to think about that, but very interesting. If anybody has a thought on that, please let me know. And then we have, might I suggest sending sample voir dire that was mentioned with the PowerPoint slides? Yes, I will send, this is another great idea. I will send those to use it in voir dire, super helpful. Okay, Amy, that's good. I will send those things to Brooke and she can send that out with the slides. So I'll send those things. And again, if anybody wants additional information, just let me know. As we get to the end here, so we're going to focus on the defendant's conduct, hit the highlights of the evidence, talk about the expert testimony, those experiences, use that theme to get that jury to do the guilt. And it's an argument, so be argumentative. It's our last opportunity to convince them of about what happened. We're going to talk about the jury instructions, the most compelling evidence, tell that story again, and we'll talk about reasonable doubt. Make sure the defense is going to do it. Let's explain credibility and how it is determined. Unless you have a particular issue in your jurisdiction about commenting on that, that is something you should talk about. Going forward in these cases, conduct an experience-based voir dire, meaning that we're going to connect the jury with the experience of the victim and maybe use the jurors' experiences to educate the jury generally. Guide the jury's response to the evidence from selection through closing argument. We're going to identify those issues which may require expert testimony, whether it's scientific evidence or evidence about trauma. And we're going to employ themes that place the evidence in context of common experience as we do this. Okay, that is my contact information, which we will send to you all when we send the slide deck. And if you have any other questions, reach out to Brooke, ICCR, or reach directly out to me or Aequitas generally. We've got a lot of great folks there. We also have other resources that you can tune into. We have office hours. Oh, today's the Thursday, yeah. Today was identifying the predominant aggressor. But please look out for our office hours. That's it for me. Thank you, everybody.
Thank you so much, John, for sharing your time and all of your expertise with us. It was a jam-packed webinar, and we so appreciate it. And thank you to our attendees for your engagement and great questions. Please watch your email for the webinar evaluation. Once you complete that, you will receive access to the accreditation certificate, recording, and the handouts that John mentioned. So thank you all again, and I hope everyone has a great weekend.
Thanks, everybody. Bye.
Bye.